May it please the court. My name is Jeremy Koss, and I represent the appellant, First United Bank, as a successor in interest to Old Harbor Bank. Good morning, Your Honors. May I reserve 5 minutes, please, for rebuttal?
Yes, you may. Yes.
Thank you. This matter involves some complex issues, most of which are derived from federal law. There's very little state case law that goes to the issues in this appeal. There are two main issues I'd like to discuss before Your Honors, with Your Honors' permission. And those were determinations made by the trial court on its order granting summary judgment on all counts in favor of the borrower, Trinity Corner. And those two determinations are whether the operative documents formed a unitary transaction and whether the operative documents facially manifested bilateral obligations. If the answer to either of those questions is no, then the summary judgment entered by the trial court should be reversed and judgment should be entered in favor of First United Bank on its motion for summary judgment.
There's no dispute among the two sides that this is a case ripe for summary judgment, that there's not factual issues to be determined then.
I don't think so, Your Honor. I think this is ripe for summary judgment on either side, to answer your question. As to the unitary transaction and that determination, the case is relied upon by the trial court and relied upon by the appellees in this appeal. All discuss situations where a lender and a borrower entered into transactions contemporaneously. And in those transactions, both the borrower had obligations to the lender and the lender had obligations to the borrower. And those transactions form the consideration for the borrower deciding they wanted to take that loan out, for the lender deciding that they wanted to make that loan, and for the lender taking on the obligations of that particular transaction. In those situations, almost always, the obligations of the lender were sufficient to pay the debt on the note by the borrower. Now, we don't have that situation in the case at bar. In the case at bar, the loan originated in 2004. It was eventually increased to $1.88 million by February of 2007. In March of 2007, a 10-year lease was entered into between the lender, Old Harbor Bank, and a third party called Trinity Town Center. Now, Trinity Town Center is related to Trinity Corner. There's common management and some common ownership, but they're not wholly owned subsidiaries of one or the other.
There's a principle behind both, but each of them in terms of like filing tax returns and things like that are separate entities then? That's
correct, Your Honor. Absolutely separate and distinct.
But you seem to be adding into the notion of a integrated transaction or unified transaction, this concept of mutuality, right? But I don't see that in the case law. I mean, the case law talks about documents that are executed close in time, that may refer to each other, that are all part of the same scheme, the same agreement.
That's right.
And I just don't see how. The note here refers to the hypothecation agreement. I mean, how does this not meet that kind of test?
All right, so there's two aspects. There's the integration aspect, and then there's whether the documents manifest bilateral obligations. The mutuality goes to those bilateral obligations. Whether they're integrated relates to the timing of the transactions, what the intent of those transactions were, who the parties to those transactions were.
Let me ask you in that respect, before things went south in this lawsuit and now after the final judgment in this lawsuit, the answers may be different on these. On September 5, 2017, what happens? The note balloons at that point in time. What's supposed to happen then?
Well, what's supposed to happen is the borrower is supposed to pay off the loan.
And do we have an amortization schedule so we know what that payoff is?
We do not have an amortization schedule, and I apologize. There is no amortization schedule that's set forth in the record that I'm aware of, and counsel for the appellees may correct me. Suffice it to say...
Well, and in that respect, and this may be a stupid question. It's not the first one I would have asked. But there's a memo, I believe, if I'm, hold on. The memo from the bank president to the board, and he talks about that. Let's see. Yeah. The note was going to balloon before the end of the lease, some months. And then he says, the prepaid rent asset on our books would then burn off over the next 9 months of the lease. What does that mean?
I think what that means is that there was prepaid rent that was already made, and so it's basically going to be applied for that 9-month period.
Lease.
Well, it'll be applied to the lease. It's not really going to be applied to the loan because it's already paid.
The loan's ballooned.
The loan balloons. So in the record, it does show that that note had a 27-year amortization. It originally had a short interest-only period, and then it was amortized over 27 years.
So even if all the lease payments were made, the balloon payment must be $1.5 million or.
It's a big balloon.
It's a big balloon payment.
Very large.
As they often tend to.
Very large, because you're talking about 8 years of lease payments versus 27 years.
Now, that date is still coming, and when it comes, is it your understanding you can still enforce the balloon payment?
Absolutely. Well, we sought to enforce due to a non-payment default.
Right.
If they're
Right.
not in default right now because of the reasoning of the trial court, does that do anything to prevent the balloon payment coming due when it comes due?
Absolutely not. We would be entitled to sue for a matured loan,
Right.
and for whatever that balloon amount that was due, we'd be able to sue for that based on a matured loan. And if it wasn't paid off when it, at the time of maturity, that would constitute a default also, which will allow for foreclosure of the mortgage and a suit on the note
Okay.
as well.
At least some of the cases, it appears that the entire transaction is integrated because one part of it pays off the other part of it. And as the other judges on the panel have raised, there's a balloon here that doesn't appear to be paid off. Are there any cases that have a similar factual situation that there is a remaining debt after one part of it is paid off?
Not that I could find, Your Honor, and I've done extensive research.
But regardless of that, this whole thing went south well before those events occurred.
That's correct.
Okay, and so it seems to me, fair reading of the transaction here is, obviously the lease payments were set and the note payments were set to be the same, and when there was going to be a credit, right?
That's correct.
Okay, and so you were trying to foreclose based on some default in the payment, when at the same time you have disavowed the lease where there was going to be a credit. And the question is can you foreclose under those circumstances?
Well,
Forgetting about whether the underlying debt is going to come due according to its terms. And isn't that what this case is about? Are you entitled to foreclose where this has happened?
it's exactly what this case is about.
And isn't it a reasonable construct to say, obviously, this whole thing was put together so that the lease and the payments would offset each other until the time came for the balloon? And that was the nature of the security that was given.
Certainly the lease payments were
They were
reduced.
adjusted. It was
They
all
were
adjusted to match.
To match the note, and that was done at the time in September of 2009.
Right. And whether it would ultimately pay off the debt or not, those were the terms of the security.
The security was an assignment of rents and also a hypothecation of rents,
Right.
plus the mortgage and the note.
Right. And the agreement was, though, that this was all balanced out.
It would balance out.
No dollars were going to change hands.
It would
during the course-
it would
this
balance
course.
out for an 8-year period, at which
Right.
time it
So
would
for
balloon.
For all that paper, that period, this is basically what I'll call a paper transaction where the bank recognizes the payment on the note by accounting showing the payment on the lease. No money's really going back and forth at all. It's just that the bank is supposed to be making accounting entries on the note and on its expenses for the lease, right?
That's right, unless there was some other situation that created a default under the lease.
No, but
first
that,
or the note.
assume the deal worked, that's what was gonna happen.
Gonna happen. And so there could never be a default on the note, because the bank was gonna be paying itself for the note for that period of time.
Not necessarily true. There's many other defaults that were possible other than a
But
payment
at least for
default.
non-payment, that's the only thing that could happen.
For non-payment of the amount due under the note, but for non-payment of taxes, non-payment of insurance, failure to have insurance, there's a myriad of different possible defaults that could have occurred.
Right.
That would have nothing to do
But in this
with the bank's
particular
payment.
case, the allegations apparently are that the default was non-payment on the note.
That's correct.
Okay.
That's correct. That's the allegation. Right.
And who was it that stopped making the accounting on this thing? The timing on this is a little confusing. Was it First United after they took over from FDIC, or was it
No.
before
The
that?
FTC shut them down, I think.
The record shows that there was apparently a non-payment under a lease. The FDIC shut down Old Harbor Bank.
So the only way there was a non-payment was that Old Harbor apparently stopped making the accounting
That's right.
entries on its own books.
That would be correct. And then First United Bank obviously bought this asset from the FDIC along with other assets as
Okay.
well.
But by
Okay.
then, the landlord had accelerated under the lease before FDIC shut them down.
The record shows that there was an acceleration notice that was sent to Old Harbor Bank.
Right.
Right. But to get back to Judge Silverman's question about this integration, there's different aspects of integration and different levels of integration. You can have documents that are related, and certainly these documents are related. There's no doubt about that. And we've been talking about how they're related. But related does not equate to integrated. And integrated is, in essence, a unitary transaction. And the reason that these documents are not integrated is because they don't facially manifest bilateral obligations. Now, all the cases cited in the summary judgment order and all the cases relied on by the appellees in their brief are situations where, again, the transaction arose contemporaneously, the lender was giving something to the borrower was giving something to the lender. And in those cases, across the board, there was express and clear language in those documents that said the borrower is excused from performance if the lender defaults on its obligations. And that fact is crucial because you don't have that in our case. You have a promissory note that simply references a hypothecation of rents as additional collateral. That's it. Other than that, it does not reference any
The note is
portion.
further secured by a collateral assignment of leases and rents modified herewith and by assignment of leases and rents from Trinity Town Center LLP, the
That's
hypothesis.
That's correct.
And that's in the note.
It's in the note. It's basically saying that you're giving me a hypothecation of rents and a revised assignment of rents as collateral for this loan.
That language would exist in a non-integrated
And,
situation if it
and,
was
I'm
purely
sorry.
a real estate financing transaction where there is security given for the transaction, correct?
That's correct.
But it
That's
also
standard language.
references to the modification of the lease in that language that Judge Altenburn just read.
No, it doesn't.
I mean, isn't that what it says, modified herewith? or
No,
is
that's the assignment. There was already an assignment of rents. When the original mortgage was given in 2004, there was an assignment of rents given by Trinity Corner.
But the rent amount was adjusted
The
at
rent,
that point.
the rent
as
amount,
part of this transaction.
the rent amount was adjusted as part of this transaction to match the note payment.
Right.
But again, that's not enough to cause integration. Again, it means they're related. There is no doubt they are related, but it does not mean that they're integrated. Because to be integrated under the case law that's relied on by the trial court and by the appellees, you need much more than simply referencing another document. You need something more than documents being related. They have to have provisions in them that show that they're intended to be unitary. And typically, that's cross-default language, as we find in every case, or the lender has to be seeking to enforce a document that its own obligations arise out of. In some of the cases, they talk about a lease or a lease with a sublease. And in those situations, the lender is seeking to enforce that document, but the defenses that the borrower has arise out of that same document. And because of that, that's a unitary transaction. And it's,
We're already at 15 minutes. We asked you a lot of questions, and what I'm going to do is just extend this argument by 3 minutes on both sides. So you've got 3 more minutes, and you can use it now unless you think you're finished. So.
I'm fine. I'll just stick with my 5 minutes of
Okay.
rebuttal. Thank you, Your Honors.
All right. Mr. Dykus? Before you get started on this, you probably will know the answer to this. Judge Rondolino's name is on the relevant order on summary judgment, but I'm not real confident he's the one who actually did the work.
Actually, he did, because the work in this case, aside from the discoveries of summary judgment, Judge Minkoff.
Just came in at the end then on this?
Right.
Okay.
Judge Minkoff, but there was little activity before the court, before this, other than motions for extension of time. So it was the new foreclosure division, well, it's not new anymore, foreclosure division that had been established, and Judge Minkoff was in charge of that. So he had he had all the foreclosures, commercial and residential, but then he would assign a certain judge to handle certain matters, and that's what happened to Judge Rondolino. His number was up. So let me just say, and I'm going to address the specific arguments because I think I see what the hot issues are here. But what Judge Rondolino did do was he looked at the facts, he looked at the law, the same law that Mr. Koss has addressed, and he decided that this matter was determined on its merits by this singular question, which is the focus of our brief, the focus of the reply brief, and that is whether, as a matter of law, the loan and the lease form a single integrated transaction. And we respectfully submit to you today that if that is the case, as a matter of law, these various documents formed a single integrated transaction with bilateral obligations, which are clearly manifested in the documents, then there's no reason to worry about the arguments, and it appears that the appellant wasn't addressing several of those arguments as well.
Mr. Dykus, let me ask you the same question I asked him, which is what happens on September 5th, 2017? Does that balloon payment still come due after this judgment was entered?
The answer to that is yes, it balloons. The balance of the payments come due, but this sounds a bit circuitous. But I noticed that all three of you addressed that issue. That issue is really beyond the four corners of the document. I don't think we should even be looking at what happens in 2017, whether...
Well, is it your position that this judgment is going to be res judicata as to payment at that point in time?
Oh, yes. Oh, yes, because the law is very, very clear that if you have bilateral obligations and you elect
So that
to...
everything gets discharged by a breach?
It gets discharged by the breach.
Okay.
You can't repudiate the lease, which was the sole source of the funds, without repudiating the note. And it excuses the note.
I'm going to get lost in the names here, but so I'll call them landlord and borrower.
Okay.
When landlord decides not to accept the payment of the lease and to give it to lender instead, what happens on their books?
Asking that one more time?
Well,
Sure. I'm not sure to get that.
there's a landlord that's supposed to get income
Right.
and didn't here. It got used to pay the expense of the lender.
Mhm.
And these are two separate and distinct legal entities that are
Yes.
separate LLCs. What happens on their books with this thing?
Well, they assigned the lease payments. They were no longer entitled to the lease payments. They assigned them, and in that assignment, they directed that those rents go to the bank. And the bank bilaterally, which is manifested in the documents and shows the integration, the bank agreed in that hypothecation agreement that it would credit the lease payments against the note. And that, of course, is what they repudiated when they rejected the lease. So what happens on the books it's just not receipted.
And the only one of these trinities that is here today is Trinity Corner LLC.
That's right. And the law is very clear, the Supreme Court on down both federally and state, that two parties, in this case the landlord and the bank that was the lender, could reach an agreement to benefit a third party, in this case, Town Corner, and that's what they did. And that vested Town Corner with the right to affirmatively defend the repudiates the obligations on the note.
Yes, so Town Corner is the landlord, it's the shopping center.
No, and that is
that right?
confusing.
Yeah, it is.
Town Center.
Town Center is the
Town
shopping
Center.
center. Town Corner is the.
Town Corner is the borrower. Town Corner is the borrower.
Right.
And so what happened is the lender, Old Harbor Bank, entered into the hypothecation agreement,
Right. No, I
assigning the
understand
lease,
how the
assigning the,
transaction
right,
worked, but
for the benefit
names
of
get
Corner.
confused, right.
For the benefit of the borrower, so that then the sole source of the funds on that obligation between
Was the
Town
lease
Corner,
payments.
the borrower, and the lender.
And when the hypothecation assignment of rents was entered into, who was actually the general partner of Trinity Town Center LLLP?
It wasn't Trinity Town Corner, as the documents reflect.
So who was it?
I don't remember, Judge. I don't remember who it was. But
Is it troublesome that the hypothecation isn't signed by the actual general partner of the party that's assigning this lease?
No, and for this reason, that ignores the fact that the drafter of that document, Mr. Kempton, Attorney Kempton, signed an affidavit which is not disputed that was a Scribner's error when they designated Town Corner as the general partner of Town Center. And Attorney Land White, who was representing the Trinity entities, confirmed that was a mistake, and maybe perhaps in his affidavit, I'm not sure, he may have addressed who the actual one was. But the bottom line is a Scribner's error, and it doesn't matter. I might add, Judge, notwithstanding, Your Honors, notwithstanding that Scribner's error, the bank went ahead and accepted the benefit of that bargain, and they enjoyed it for 2 years until they elected to reject the lease.
The parties proceeded under this agreement.
They proceeded and acted under the agreement for a good, healthy 2 years, which of course stops that argument.
Remind me, in terms of the inception of the loan, this did not start out as what you're suggesting is bilateral or integrated loan, correct? At the very
in the
inception?
beginning?
Right.
Well, no.
To the extent the record
Right.
addresses this,
Right,
walk
right,
me
right.
through how this all started.
That's important, and I may be off a little bit on the dates, but back in, there was an existing lending relationship for several years between.
And at that time, Old Harbor was the lender.
Yes,
And it was not a tenant. It was not renting the building at that time?
they may have been renting the building, but there wasn't an integrated agreement to let the rent settle.
I
Right.
think
There
that,
was
if
no
I
option.
understand it correctly, they were already in the center when this transaction occurred.
They
in
were.
any event.
They were, which means this is a new transaction, and it's important because the appellant referred to the 2004 loan and referred to documentation in 2005 and language to the effect in those documents that the mortgagee is not responsible for any other obligations, including the lease. That was the financing by Town Corner. So when Town Corner entered into the loan, Town Corner also had a tenant, and it assigned that tenant to them. It assigned that lease to them for the benefit of security. So it wasn't the same thing as this transaction.
But what the trial court found in its order is that Old Harbor decided to renew and advance additional funds,
Yes,
and there was additional collateral that was put up for those additional funds.
that's correct. That's the new collateral.
But that doesn't create a new loan. It creates a renewal, it creates an extension, correct?
Well, no, I think what happened was the bank got together, they looked at the transaction, it was time to renew, and they had to make a decision. Are we going to create a new loan? Are we going to renew, which is a new loan? And there's the memorandums back and forth, which I believe Judge Northcott referred to, where there was a memorandum of the CEO saying that what we're going to do now is we're going to take these lease payments from the sister company, Town Center, and we're going to tie it to the loan obligation. And for consideration of that, we're entering into a new note.
It's merely using these rents as an assignment to pay for the note for that relevant period.
Yes.
And I'm still struggling with, I think I understand why there may not be a foreclosure here, but why does that so tie them that the breach makes the note unenforceable?
Because, simply put, that's the law. You can't, if you have a bilateral obligation, which clearly we have, the bank has an obligation to lend, the bank lended, the lender has the obligation to, the borrower has the obligation to pay that monthly payment. And there was a bilateral agreement here that we're going to lend you this money, we're going to renew, we're going to modify the mortgage, which they did, and by the way, the mortgage also refers to the hypothecation and the loan.
And there were additional sums advanced at this point, correct? This was
Yes.
not just like a refinance of the note. This was not.
Right,
just
there were
just
additional
a
sums.
renewal of the note.
Additional sums, albeit $78,000, which the appellant mentioned. But the point is, in consideration of this assignment by Town Center of those rents, it was agreed that they're going to make this loan, and they're going to advance more money. It was a new loan, it was a new mortgage. The terms of the note refer specifically to the rents and the hypothecation, and so does the mortgage. And so there were bilateral obligations. So to answer your question directly, Judge Altenburn, when you have bilateral obligations, and the bank has to perform, and the borrower has to perform under the lease and make those payments, and you reject the only source of the funds, then you've repudiated one aspect of a bilateral deal in a unitary transaction. And when that happens, it's a defense, according to the case law, that you have also excused the performance, in this case of Town Corner.
Let me ask somewhat of a hypothetical question. A bank wants a new building, and it has a longtime customer who's in the contracting business.
Mm-hmm.
And the customer says, I've got a piece of property, or I want to acquire a piece of property, I can do a build to suit for you, and this is a great investment for you, it's a great deal for me, you can be my tenant for 10 years, and then if we still like the situation, you stay, you don't like it, you leave, we get another tenant because it's a nice bank building. Why would that be different from the scenario we have here? Is it purely a question of the language that's used, or is it the ultimate appearance of the transaction that's controlling?
Well, on the face of what you said, there isn't a difference. The question becomes, under those circumstances, I'm assuming under that case there was an agreement that the fact that it was built, then that the lease payments would set off the obligation on the loan under your scenario.
Right.
Well, the difference is, and I think you're referring to 3 or 4 of the cases cited by by the appellant, and also when they tried to distinguish the Hackle case, WHR, in those cases. The difference is, in those cases where they're said there's not a breach of a bilateral obligation, there is specific language in either the mortgage or the note that says this is absolute and unconditional, and that's the In re Point case. It says that this is controlled by the note is absolute and unconditional, and nothing in the lease or nothing in the hypothecation can impair that payment.
You also have cases that say if there is a default under the lease, then the note is unenforceable. And you don't have that here, correct?
I'm not sure that I recall that law, but what happened was there was a default under the lease, and there were the 2 letters of accelerations months before they before the FDIC came in and declared it insolvent. And so that accelerated amount due, and I'm not sure I'm addressing your question, Your Honor, but
one of the things you've heard the panel question is the balloon, and the
Mm-hmm.
fact that there is an ongoing obligation after the lease terminates. And there is some language that I think supports your position in the documents,
Mm-hmm.
and I think there's some language that's omitted from the documents that would have strengthened your position had it been in there. And one of the things I'm struggling with is what to do with this balloon. It's clearly not, it is not fully bilateral in the sense of if the lease goes away, the obligation goes away.
okay. You have to focus on exactly what is the bilateral obligation of each party. The bilateral obligation of each party is, on the bank's part, was that we've agreed to credit those payments against the loan. That's the agreement. Not that the lease payments are going to satisfy the entire obligation. And that's why I said earlier that I don't think we look beyond the specific language of the bilateral obligations. We don't look to what's going to happen in 2017. It may have been paid off, there may have been a default then and a foreclosure, but all of that is for naught. because what happened was the bank's specific obligation to credit those leases was terminated. It was repudiated, and that excused Town Corner. So
And that's implicit even though that language is not expressed in this agreement, and they were structuring something where everyone knew there would be a sizable balloon payment at the end because the lease was barely
Right.
paying more than the interest. Is that right? Is that the
Exactly.
law? You don't have to have the effect of the default in the agreement, that just occurs as a matter of law in this situation?
Well, again, you have to look, what was the obligation? The obligation of the bank was to credit the lease payments,
Right.
and they reject the lease. And you can't do that. The fact that
And I can easily do that. I can say it all comes due, I take it off the note, and they don't have to pay anything until the balloon comes. We calculate the amortization as if the bank had fully paid and performed on the lease, and there's an amount due.
But they
That's
didn't
easy to do.
But they elected not to do that. They elected to repudiate the lease. They elected not to do that. They affirmatively made the decision that creates this problem.
And they repudiated the lease when it was already in breach by the predecessor, right?
Yes. But at that point, at that point, the borrower had already accelerated. At that point, according to the law, the rights and obligations of the landlord were set. And that was the full amount due under the lease. So do they take that, as you said, and credit it? No, they reject the lease. We don't owe you the full amount under the acceleration, which was fixed at the time that the FDIC declared it insolvent. Because the law is clear that that the rights and obligations of the party are set at the time of that. So before that, the borrower had accelerated. Town Corner had accelerated twice in a breach of notice.
Without regard to the FDIC and all of this other stuff, if the bank itself had just said, we're just going to fully default on this lease, we're not paying any more, I still don't understand between these two parties why the remedy would not have been to give full payment to Trinity for all amounts that were due under the lease that they have now want payable in its entirety at this point in time. That reduces the note down, and when it balloons with whatever's left.
But they didn't do that. They didn't do that. What they did was
But isn't that if you have a breach, isn't that what happens?
Well, but this breach is a repudiation of a bargain for obligation on the part of the bank. And that repudiation clearly excuses the
So you're saying
obligation.
the First United / FDIC might have done that, but they didn't.
Yeah, no, they didn't. That's exactly right. In fact, they rejected the lease.
They haven't said, we give you a credit, in our attempt to foreclose here, where they haven't claimed, said, well, what we're owed is less the accelerated amount under the lease. They've said we repudiate the lease.
Right, that's correct. And so when they repudiated the lease, they repudiated the very same thing you're talking about. They repudiated that accelerated obligation, all money due under the lease. So when we hear about an absurd result, when we hear about a windfall, we have to say, well, who instigated that windfall? Who created the seeming unfairness? It was First United, because First United had the agreement. They knew what the agreement, the bilateral obligations were manifest in the documents very clearly. An integrated agreement, signed, an integrated transaction signed at the same time, referring to each other, and it's the same subject matter. It's the renewal of the loan.
You're at 18 minutes, there's no penalty for quitting early, you've got
I
nothing more
know
to say.
that. I had more to talk about, but I think I know what your concerns are.
We don't actually give you points for that either. You have our sincere appreciation.
Thank you very much.
Thank you,
So
Mr.
we
Dykes.
respectfully request that the lower court's judgment is affirmed.
Okay.
Your Honors, what was being discussed with a police counsel is the issue of recoupment. And the issue of recoupment was, in fact, something that was raised in the pleadings. It was really not addressed by the trial court in its order. Now,
Was it argued to the trial court by your side?
it was argued by both sides. It was extensively briefed in the lower court, and it was certainly argued, but it did not form the basis for that order. So it really wasn't, I don't know that it's right for this court, maybe Your Honors think that it is, but it really wasn't something that was ruled upon by the lower court. We don't believe that recoupment is proper, and we briefed that on why it isn't, and there's no mutuality of obligation, no mutuality of parties. And that whole argument kind of dovetails into my main argument, and that is these documents are not integrated. They do not facially manifest bilateral obligations. Your Honor was talking about the Accardi case, and the Accardi case was, they said, documents are not integrated, they do not form a unitary transaction. And they noted that the successor bank wasn't a party to that lease in question, that 10-year lease for the bank building. So the problem that I have with the argument of the appellees is they keep arguing one side of the transaction and saying that creates bilateral obligations, but not showing how the other side does. There's a lease with 3 addendum. There is not one mention of the loan or the note in that lease or in any addendum. It doesn't mention it. Now, how can a transaction be unitary, and how can documents be integrated when there's not even one word in those documents that mentions a $1.96 million obligation? It's not in there, and because it's not in there, these documents are not integrated, they do not constitute a unitary transaction, and they do not facially manifest bilateral obligations. Now, it's interesting to note, when the lease was signed in March 2007 by Trinity Town Center, LLLP, with Old Harbor Bank, the borrower, Trinity Corner, already owed $1.88 million. Now, in September of 2009, the loan comes due, it can't be paid. The bank says, don't worry, borrower, we're going to extend this and help you out. But if we do that, you have to pledge these rents to make sure that we're going to get paid, because there was no other source of repayment. And they advanced $78,000 on a $1.88 million obligation. And what happened with that $78,000? $62,000 was used to pay past due interest, and $16,000 went to the borrower. And by the way, the general partner of Trinity Town Center LLLP is Trinity Town Center LLC, not Trinity Corner LLC, to answer Your Honor's question. And based on
Does the record reflect who owns these LLCs? I mean, is Mr. Plains, I guess his name is, the sole principal behind all these things, or are there different people, or does the record not reflect?
There is deposition testimony as to the ownership structure of Trinity Town Center LLLP and Trinity Corner LLC. Mr. Plains is the manager of those entities, but there are other owners of those entities, and they're different owners. They're not the same. And based on our arguments, Your Honors, we respectfully request that this honorable court reverse the summary judgment entered by the trial judge and order summary judgment to be entered in favor of First United Bank. Thank you very much for your time.
Okay. Thank you.